We wish to issue the following directions on how we are going to proceed. For good order and pursuant to Rule 17 of the Rutunga Rules, which empowers the court on its own motion to consolidate matters for expeditious disposal, the following petitions are hereby consolidated. Petition number E365 of 2024, where petition E013 of 2024, E014 of 2024, E015 of 2024, Nairobi petition E565 of 2024 shall be the lead file. All filings henceforth shall be made in the lead file. Now, pursuant to that consolidation, the parties shall appear as follows.
Okay, so the new order of appearance of the parties will be as follows. HA, the Gachagua, will appear as the first petitioner. The second petitioner will be Thomas Kimoto Maingi. The third petitioner will be Honorable Jane Jerry Maina. The fourth will be Honorable David Munyi Mazenge. Fifth will be Peter Gichobi Kamoto. Sixth petitioner will be Grace Mononi Mwangi. Clement Mochiri Muriuki will be the sixth, and the seventh will be Edwin Monene Kariuki. The respondents will appear as follows. First, to the fifth respondents, as they appear in E565 of 2024, that is the Speaker of the National Assembly as the first respondent, National Assembly, Kenya the second, Speaker of the Senate will be the third, the Senate of Kenya will be the fourth, and the Honorable AG will be the fifth. HE William Ruto, the President of the Republic of Kenya, will appear as the sixth respondent. And the interested parties, the first interested party will be LSK as first interested party. That is the second one. The second one will be Professor Kithure Kindiki as the second interested party. Unless there's a party which is left out.
Yes, my lord, with your
Just a minute. Is there anybody who has been left out and come to amend consolidate these petitions? Yes.
My name is Moto Teresia Wanjiru, Testimonial and Company Advocate. I was left out in the morning in petition 2013 of 2024. I had not been notified, and therefore I learned of these proceedings in the nation TV, and I decided to come. So therefore, yes, I came all the way from Kirinyaga because Judge Richard Moore was very clear that we are going to be notified once the file is forwarded before the Chief Justice. There was no communication. So we were left stranded. What is happening? And our petition is being mentioned here today. And therefore we have had to rush very fast so that I can make it in the second session, like afternoon session. Therefore, I wish. Yes, maybe perhaps we can.
Section E13 and E14, Kagwea.
Yes, it was consolidated and we were told that we are going to be notified. However, we were not notified. I just learned of it today on the TV at 11. So we had to rush very fast from Kilgoya so that we can understand what is happening and perhaps clarification purposes.
Is there anybody who has been left out of the...
My lord, with your permission,
Yes.
just to draw to the court's attention, there is an application lodged on behalf of an interested party in the name of United Democratic Alliance, which can be considered at an appropriate stage. Thank you.
Intended interested party or interested party?
He's an intended. He has not yet joined us.
And my lord, on the parties,
Yes.
in this petition, I'm assuming it's one of those that you have mentioned, 528 of 2024.
No, it's not.
We have not mentioned that question. And,
Oh, okay.
and on that score, let me say this, that in the morning session, there were parties who had mentioned different petitions which were not before us. I think we should be very clear that we can only deal with matters which are before us. Should there arise a need for us to mention any matter which is not before us and which has been placed before us, we shall make that communication. So I think we need to be very clear that our jurisdiction is prescribed to particular facts. Thank you very much.
My Lord, your leadership, permit me to request that the E565, in which the Deputy President is a petition, and E015, in which the Deputy President is a first interested party. Let the record of this noble court show that we were not given an opportunity to be heard on the issue of consolidation. The record shows the court has acted of its own volition in the normal practice, even under the Mudunga rules, is to accord parties to state their views on a proposed consolidation. This is the court's own volition. We were not asked to give. Thank you.
Your Lordship, we have had the orders that have been granted by the court, consolidating the matters and creating another lead file. And that creates the problem we were trying to address in the morning, Your Lordships. That now this bench has created two lead files. We have 6 files that are before you, Your Lordships, with the lead file being E522. Which files are not before you? We have now created another lead file, E565. Your Lordship, those are some of the issues we were trying to raise in the morning. That if those other files were before you, this confusion would not be rising.
Mr. Ndegwa, there's absolutely no confusion in these matters. Let us not give confusion where in terms of consolidation, we have cited the rule under which we have added Rule 17 for avoidance of doubt of the Ntunga rules. I think we need to move forward.
Yeah, and my lords, on behalf of the respondents, we confirm that we are ready to move forward. I think too much time has already been taken on issues that are not of any substance. Save, we would like to make two proposals. First, we would like, my lord, having read what has been filed by our colleagues this afternoon, we would like to propose that their application for recusal and this application questioning how the panel was put together should be had together. For the very simple reason that they rely on the same set of arguments and facts. And I draw your attention to paragraph 5. They say that the impartiality of this court, the one we are before, has been questioned. And at the end of their prayers, they say that it is therefore in the interest of justice that this honorable court recuse itself. It would be gravely injurious to the respondents if they were allowed to prosecute this application, take one bite at attacking the court, then however the court rules, bring the other application for recusal and take a second bite. We would like to argue both of them together. Secondly, we would like an allocation of time, because it is quite clear to us that in the absence of directions allocating time, we are going to have another long afternoon of long-winded speeches that do not address the specific issues. We are willing to say in advance that whatever time you give us, if you give 10 minutes each, we shall accept. If you give 15 minutes each, we will accept.
Professor Gifu, which applications have been filed?
Yeah.
How many applications?
The one you directed, my lord, in the morning.
Yes.
But it is in that application that has been filed by Jindo Matiba and company advocates. That is the application that seeks, on the one hand, that questions how this bench was appointed, and on the second hand, it requires the recusal of this bench.
So for avoidance of doubt, it is one application.
It is one application.
There are 3 applications.
But there is an earlier application for recusal. And that's why I'm saying we probably can hear both of them together.
Yes.
I'm sorry, my lord, but my lordships and my lady, I just wanted to remind the court of Article 159 of the Constitution. In exercising judicial authority, the courts and tribunals shall be guided by the following principles. And 159(2)b, justice shall not be delayed. So I'm requesting your lordships and my lady to kindly refer to that provision and let us move forward. Thank you.
But let it come on record that this is the first time in which, on a matter of extreme national importance, we've been given 1 hour to be able to do an application, serve it, and come back to court. we have tried to do the best that we could in terms of complying with those directions. Of course, one of the issues that we could not be able to do is that the written application could not be able to do full justice to the instructions that we've been given and to our case. And therefore, my Lord, when Professor Gedu Muigai stands senior counsel to say that we need to be gagged on the issue of time, we protest. We shall require sufficient time. This sufficient time is not forever. This sufficient time, at least for purposes of the three, presenting the one of that application, is 1 hour. It is a list that people deserve in an application of this nature. Secondary issue, my Lord, is the issues of consolidation. Those issues of consolidation are as different as UDA can be from Jubilee. And the issue is, for purposes of the difference, the application under Article 165, and we did not hear you talk about the inclusion, because we've had to include. Their earlier complaint in the morning.
I'm sorry to say this.
I have.
Yes, I want to interject. If my learned friend is appealing against your orders, then there is the right for it. My lords and my lady teacher.
There is no, I'm responding to what has happened. Let us be fair to each other. And my Lord, what I'm saying is this, that for purposes of those applications, the application under Article 165, because in the morning when we raised the issue orally, the questions that was raised, you are raising issues against the Deputy Chief Justice, who is not a party. She is a party now, and we have served her. We took the application on the issues of the constitutional violations regarding the empanelment of this bench. We shall need the court's directions on that issue. And we've gone through the authorities within the short period that we were here. So we are standing on solid grounds. We just need sufficient time to do our business. Issue number 2, my Lord, if that applications were to succeed, then it would effectively mean, as my learned colleague Mr. Ngoya had indicated, that then the issue of recusal of your lordship becomes academic. But if your lordships were to hold that all these serious injustices that the petitioners allege were committed by the Deputy Chief Justice King, then we shall now address you, the issues that concerns you. And I need to add, on the issues of authorities, because now we've been told instructions. When we came here, we thought that while we were proceeding and actions, prepare the team in the office, let them prepare authorities to argue on the issue of recusal. When you were given 1 hour, we told them, oh, stop on the issues of recusal, now we are dealing with another thing. So, my Lord, we cannot be able to argue, if it is today, we cannot be able to argue, as expected by our client, on the question of recusal. And there is no similarity of issues. Therefore, my Lord, I urge you that let us adopt fair procedure. This fair procedure has
is there a specific application for recusal?
There are 2 applications.
Where are they?
At least I know, Gregor will mention one. We are actually bringing them, even one of them in number 015 is an application dated, I believe, yesterday, 21st of October. There is another one.
Okay, this these are the directions we're making. We'll deal with the application before us. The application for empanelment of this bench.
Can I have application of next year?
And perhaps, my Lord, before you give the directions,
with my learned friend, Immortal. She's informing me that she was not aware of the elections in the morning, that applications be filed and we come back before you. And now her petition has been integrated in the consolidated petition, that is petition number E013. Therefore, she's not been able to file an application either for refusal or for challenging the panel. She was just requesting if she can be served with those applications and the responses, and she be given time, 1 hour just like the others, to file her single application in wishes. Because now she's participating in the proceedings.
Council, listen to this and listen to this very carefully. All of us acknowledge the momentous import of the proceedings before us. And all of us are enjoined by the rules of natural justice to do what is right. This bench is not going to be taken round in circles. We will not be taken round in circles. We are here to do justice for the petitioners, justice for the respondents. And anything which is intended to delay these proceedings will not be acceptable because both parties have come to this court under certificate of urgency. Let us be very careful how we argue our matters. We want everybody before us to get justice. That justice will not be possible if every advocate who stands up wants to take the cause in cycle. We will not allow that. I'm making final directions on this matter. The matter which we are dealing with is an application dated 22nd of October 2024 by Jindo Matiba and Company Advocates. It seeks orders under Rule 3 of the Constitution. We are dealing with the issue of empanelment. And then after that, we'll look at ruling for the way forward. So let us proceed. Let us be courteous to each other. Let us be courteous to the parties before us. Parties before us are very okay, but let's not be a theater by advocates to derail the process. I beg you. On the issue of time allocation,